Work is all around us. It defines us. And the future of work impacts nearly every person on our planet. The ILR School at Cornell University is at the center of work, labor, and employment, influencing policy and practice on the most pressing issues facing employees and employers. In this episode, Dean Colvin and litigator Douglas Wigdor discuss the impact of the Me Too movement on sexual harassment in the workplace.
Well, thanks very much for joining us today. This is a chance to reflect back on something that I was just realizing is more recent than I think we often think. So this is about 2 years since the Me Too movement kicked off, and I was just hearing that stat, and it feels like it's been much, much longer. This has been something that's become such a big part of our culture and how people think about issues around sexual harassment in the workplace. So just kind of to kick things off, I'd be really interested in your take, somebody who's really represented a lot of clients in major Me Too type disputes, thinking about what has been the impact of this movement in 2 short years.
Well, Alex, thank you for having me, first of all. And I think that you're correct that the Me Too movement as we know it started in 2017 when Alyssa Milano, who has been credited with popularizing the Me Too slogan, and she did that to encourage people to come forward and say Me Too if they had experienced sexual harassment or assault, to give a sense of the magnitude of the problem. But I think in order to look at where we are now, we really need to go way back because this has been a steady, slow movement that goes back really to the creation of sexual harassment laws, believe it or not, that started to come about in the 1970s when women were entering the workforce. And sexual harassment was just starting to come about, and the law was starting to change. Of course, you had the very popular cases of William Kennedy Smith, Anita Hill, Monica Lewinsky.
Yep.
And to fast forward, actually, the Me Too slogan actually wasn't Alyssa Milano. It was actually a woman by the name of Tarana Burke, who came up with that slogan back in 2006. And she is and was a civil rights activist, and she began to use this phrase, Me Too. This was before Twitter, but she used that slogan to raise the awareness of and pervasiveness of sex abuse and assault in society. And she was really focused on people of color and people in marginalized communities. So it's been a slow, steady process to where we are now, and things have obviously changed since 2017.
Yeah, I mean, I think think back to the Clarence Thomas hearings, right? When I was in law school, almost 30 years ago now, when it seemed like this issue was first getting that really big public attention. Maybe that's what the attention to the hashtag Me Too thing the last couple of years is that increase of public attention, right? So a refocusing again, right? And we've sort of seen these kind of, I guess, waves of attention to a problem that doesn't seem to go away.
Yeah, and it doesn't go away because of a number of different problems in terms of the people's perceptions of people who have been sexually assaulted or people who are survivors. And I think Anita Hill was a good example of this, but there are many other women, including my former client, Nafissatou Diallo, who was raped by Dominique Strauss-Kahn, who would have been the next president of France. But the problems tend to be that people, unfortunately, don't tend to believe the events happen the way someone who comes forward as a survivor says. They often blame victims. They often discount the injury, and there's a lack of care. And so those things are changing. Here we are in 2019. We're a few weeks away from the Harvey Weinstein criminal trial that's expected to start in January. And that, I think, that trial, I think, will be a really important litmus test to see really where we are. Because as we know, Harvey Weinstein's defense is going to be to attack victims and to use some of the old generalizations that people used to think were true. For instance, that if a woman came to a man looking for a job and something happened, that wasn't necessarily a bad thing, and she put herself in the position. And then if after she was sexually assaulted, she went back to see that person, that would undermine her credibility. These are the sorts of things that Harvey Weinstein in January is going to use to try and discredit the victims. And it'll be interesting to see that what happens in 2020, 3 years after the Me Too movement has really kicked off.
So you do get exactly that kind of response where there's sort of an assumption that somehow if you can show the character of the victim is not perfect, right, that undermines the allegation. I mean, you've represented clients subject to these kind of attacks. I remember the Strauss-Kahn case. We saw some of that. How do you respond to that? How do you kind of get past those kind of attacks? How do you respond to that?
Yeah, I mean, it's really hard, and unfortunately, there are even some plaintiffs' lawyers. We saw, for instance, Lisa Bloom, who had held herself out as a women's rights activist. She's the daughter of Gloria Allred. But what we found out was that she was working for Harvey Weinstein in an effort to undermine Rose McGowan and to attack her character and credibility. So this is a problem. And first of all, the courts should be the gatekeeper here to prevent these things from happening. There are different federal rules of evidence, and there are other state rules that prevent these things from happening. But unfortunately, in my experience, judges often permit discovery into things that I think that they ought not to. And of course, there's the dissemination through newspapers and social media of negative things about clients or women who come forward and claim that they've been sexually assaulted. And that's exactly what Lisa Bloom was going to do with Rose McGowan. And unfortunately, for instance, in the Dominique Strauss-Kahn case, there were the New York Post ran a story that she was a prostitute, which was blatantly false, but it was an attempt to undermine her character and her credibility. So we really need to make sure that these things aren't happening, because what they do is they act as a disincentive for people to come forward. If they know that their Facebook and their social media is going to be turned upside down, every picture they're taking is going to be examined and looked at, and the defense lawyers are going to be able to ask them questions about prior partners that they had and other things like that, it's going to be a real disincentive for people to step forward.
Yeah, I mean, it sometimes seems like there's a process where some of the cases get litigated in the PR space, right, through the media. At the same time, there's a court case going on. Are there ways in which the public pressure can be used in a positive way to help bring the claims? Does that help you sometimes?
It does. It helps because, in my experience, someone who has committed an act of sexual assault typically hasn't done it just one time.
Right.
And so in my experience, by coming forward, other people will come forward, and that obviously is a great asset to have when trying to hold somebody accountable, because the rules of evidence in certain circumstances permit other women to support the victim if it shows, for instance, a motive or intent or a modus operandi. In fact, in the Bill Cosby case, that was used, and it will be used as well in the Harvey Weinstein case. One of my clients actually is going to be testifying in that trial as what we call a Molyneux witness, but she's not the main victim of the case,
right.
but she had a similar thing happen to her that supports the victims. And so, to answer your question specifically, these things are coming out into the public is important because it it usually brings out other people.
Yeah. So one of the things that is a challenge in getting that public attention is an issue both you and I have dealt with, which is mandatory arbitration, right? And this is, for our listeners, where the employer requires the employee to sign an agreement to arbitrate any disputes against the company, right? And this is mandatory because you have to sign it if you want the job, right? There's not a choice there. And the problem you run into, it might sound good in theory, you get something out of the courts, and not everybody loves being in the courts, but the reality is this is something set up by the employer, and when you get in it, it's a private forum, so that you don't get to tell anybody in the public about what's been going on. One of the most famous examples of this was with the Fox News Me Too cases, and Gretchen Carlson there, who had a public platform through being a journalist, was forced into this private forum where she couldn't talk about her case. Maybe could you tell us a little about your experience running into mandatory arbitration and how it's affected the cases that you've handled?
Yeah, and I was involved in the Roger Ailes and Bill O'Reilly cases as well, and was faced with that identical problem. And what Gretchen did and what many others have done in those circumstances is, in an effort to get around it, although legally it's questionable whether it would ultimately prevail,
right,
was to sue individuals who they had not entered into an arbitration agreement with rather than sue the company.
So she sued Roger Ailes personally rather than Fox News.
That's right. Yeah. And because she and Roger Ailes had not had a contract that required arbitration, although she and Fox did, that arguably covered their executives and employees.
Right.
But this problem, and I'll call it a problem because in my view, it's a problem because it forces people into a confidential arbitration process before an action arises. So as they start their employment, they're given as a condition to working at the company, they're told if they don't sign this, then they can't work there. Most people would sign it and not think twice because
right.
You don't think they're going to be sexually assaulted in the workplace.
Yeah, nobody would take the job if you thought that. Right.
Yeah. And then 3, 4, 5 years later, something happens, and then all of a sudden the employer breaks out this agreement that was signed on the day of the first day of employment. And the problem is that really you're now you're forcing a decision on a survivor that is really not fair. The decision should be made at the time of filing the lawsuit. And this is not only true in the employment context, and it's also true outside the employment context. For example, I represented over 25 women who were sexually assaulted or raped by Uber drivers. And they were not employees of Uber, but when they signed up for Uber, in their terms and conditions that they agreed to when they downloaded the app, they agreed, like everybody else who got the Uber app, to binding confidential arbitration. And some of these arbitrations, believe it or not, were to take place in the Netherlands.
Right. Conveniently located for everybody taking an Uber in New York City.
Exactly. And so what we did is we did an open letter, which basically it was a letter to the board of Uber, and it was on behalf of our clients and asking them to do away with this mandatory arbitration provision. And to their credit, they did that. They've now done away with the mandatory arbitration provision for not only sexual assault cases, but sexual harassment cases as well. And there are other companies that have followed their leading views on that, which is a good trend.
Yeah, it's kind of interesting that we've seen certain companies responding this way, right? So Uber making changes. Google's the other one that jumps to my mind, right? That Google was also using mandatory arbitration, and it turns out that they've had issues of sexual harassment by at least one of their executives, and you don't know if there are more cases, but at least one major executive was forced to resign with a pretty substantial golden parachute because of sexual harassment issues, and they responded right after the Google employees started walkouts and pressure campaigns. I've been kind of interested looking at these because it seems like there are these cases where the public pressure makes a difference, the Ubers, the Googles. I do wonder, how far that spreads, right? Is that going to be effective in a broader set of employers or not, right? Does it really substitute?
Yeah, sadly, I don't think it is going to be a trend. I would hope it would be, but I don't think that will be the case. More times than not, unfortunately, I get a very nasty letter from the company's lawyers threatening both myself and my client that if they were to do anything public, that they'll sue for breach of contract and all the damages that would result from public. And we just actually sent an open letter to DLA Piper, which is one of the largest law firms in the world. You would think that a law firm would try and lead by example and not force arbitration on their attorneys who have been sexually harassed or sexually assaulted. But unfortunately, not only have they refused to waive the arbitration provision, they're defending that case in a pre-Me Too textbook manner of attacking the victim. Right.
One of the things that's striking about this area is that you do see companies that you'd think would be trying to hold themselves out as exemplars of good behavior, going for pretty hardball tactics. One of the things that I think is an interesting question that a lot of people wonder is, are there better alternatives, right? We know that, sometimes the courts aren't as friendly to plaintiffs as they might be. You've talked about, this sort of suspicion of the victim. Mandatory arbitration, right? Arbitration sounds like a good alternative, but if it's this mandatory structure, that's not real helpful. Are there other ways that we could be resolving these conflicts better? Something like mediation, right? Do you find mediation's a useful tool in these cases?
Yeah, I think so. Mediation, which is a non-binding process where a neutral person tries to facilitate a resolution amongst the parties, is definitely something that I have used over the years many times successfully. I would say, though, that a mandatory mediation process, though, is something I don't think is particularly helpful, because if somebody's being compelled to mediate, they're usually not going to really in the process in good faith. Mediation, you need both sides to be there and want to be there. So mediation's good if both sides want to do it, but if one side doesn't want to do it, then I think it's a waste of time.
Right. And so, you're not really in a voluntary situation, right? So the idea that, kind of ideally you want to have voluntary consensual ways, but, that requires two sides to tango if you're going to do that.
Yeah. I mean, unfortunately, there really is no perfect system. There are definitely pros and cons of arbitration as well as the court process as well. But I think what I would say is that at the end of the day, the choice, in my view, should be left to the victim after the occurrence of what happened, because the person's already been victimized once, and to be forced into some sort of a dispute resolution system that they don't want to partake in, to me is making the underlying violence that happened to them even worse.
That kind of ties into something that I think has been a tough issue to deal with, and that's the question of the role of non-disclosure agreements, where many times settlements of these complaints involve a non-disclosure agreement. So you get the settlement, but you can't then talk about what happened. And that strikes me as a tough issue because then you're no longer able to communicate what happened and bring attention to, what could be a serial perpetrator. At the same time, you can understand the victim's desire not to have, to want to have privacy themselves and to have their reputation attacked in the public. What are your thoughts on the non-disclosure agreement problem?
It's a really difficult question and situation. I think that Gloria Allred has been unfairly attacked, for example, by Jodi Kantor and Megan Twohey, who wrote the book She Said about the Weinstein case. They did a podcast in which they essentially blamed her for entering into confidential settlement agreements, and that's because people didn't know about it. It permitted Harvey Weinstein to continue to do what he did. But it's not that simple, because as you just noted, many of our clients don't want to do anything public. And so, of course, the company's paying for confidentiality to some extent, but our client also doesn't want their name out there. And not every client, but a lot of clients. And so I think you have to give ultimately the survivor the choice of what they want. But what I would say is this is the one thing where the law really needs to develop, is in terms of holding executives, directors, and officers liable for the conduct of their senior level people who they know have engaged in unlawful conduct and have settled cases in the past. We saw with Harvey Weinstein, his brother Bob Weinstein and the other directors and officers know about his conduct. The same thing was true with Bill O'Reilly. Fox knew about his conduct. But unfortunately, the way the law on holding directors and officers liable goes back to the beginning of time. And the only way you can hold a director and officer liable for an intentional act of someone like Harvey Weinstein is where the defendant, Harvey Weinstein, uses what we call a chattel, uses some sort of equipment from the company, and so basically, unless they use like the company car or they do it on the company property
or at the office,
there's no way of doing it. But of course, what we know is that most of these sexual assaults take place either in hotels or somewhere else. And so it doesn't really address the question is whether it's foreseeable or not. Should the directors and officers know that this might happen? Is it foreseeable? But unfortunately, the courts have not adopted that standard as of now.
I think this does feed a public cynicism about the law in this area, as well as the liability. Talking about, there's also the situations where companies do, get the person to step aside, a sort of exit from the company, and they walk away with, tens of millions of dollars in some executive contract, which at the same time, if regular rank and file employee is terminated, they get nothing, right? There's no just cause, there's no severance. But then you see examples like this Google one where the executive walked away with tens of millions of dollars in a golden parachute. And, I think, feeds outrage.
Yeah, I mean, we just saw, WeWork's CEO and founder, Adam Neumann, walk away with hundreds of millions of dollars. And I represent his former chief of staff, who he marginalized and sidelined when she came back from her maternity leave, and paid her less than somebody who was doing the exact same job as she was. And so, with Bill O'Reilly, it was even worse. They renewed his contract, knowing that he had engaged in these types of conduct, and put a provision in his contract where he would have to pay a certain fine if he did it again in the future. So they actually contemplated that this would happen again.
One of the things I think is significant about the Me Too movement, when we look at the public attitude about the fairness of our system, our economic system, and structures of power in our corporations, is that it exposes sort of a lack of accountability in the upper echelons, right? When you see the sort of the Harvey Weinsteins, the Matt Lauers, the chief executives who've been getting away with this for a while, and they don't seem to be genuinely held accountable often, right? Even if there's a successful lawsuit, it's often the company paying the money, right? And so you do get this public frustration.
Yeah, I mean, it really it emanates from the lack of senior women in C-suite positions, and having very few women in these companies who are the CEOs or running the companies, who, in my view, wouldn't tolerate this conduct and turn a blind eye to it. Yeah. And so we obviously see it now going on with NBC, and then we've seen even with the National Enquirer, buying stories and like stories that would never see the light of day with Karen McDougal, right, like that. So
burying the story.
Yeah, burying stories, paying off people to bury stories. But that's really what the Me Too movement is about, and we're not done with it yet. But it really is all about giving people the ability and power and the confidence to be able to come out and say, I was sexually assaulted, I was raped, even if that person who raped them or sexually assaulted them is a powerful person. And some of the stigma, not all of it, and the blame and the discounting is now dissipating, and we're starting to move in the right direction. But I do believe that there's so much more to be done, especially on the legal front, in terms of some of the laws and evidentiary things that still, in my view, make it a lot more difficult for victims to ultimately prevail.
Yeah, I mean, I think one of the things that we've seen, this problem's been around for a long time. There's been attempts to start addressing it. I think the Me Too movement has picked things up in terms of giving prominent attention to it, but it's really clear that we're going to be dealing with this for a long time to come. This is not something that we're going to have any kind of quick fix, and it's going to be a social problem we need to keep addressing.
Yeah, that's right. But you know what? We're going to have our first female 007, Lashana Lynch, soon, so we're making some progress.
We're making some progress. First female Doctor Who as well for fans of sci-fi. So, let's see what happens. Thanks very much, Doug. Yeah, real pleasure talking.
Yeah, you were great. Very easy to talk to, so I appreciate it.
Thank you for joining us for Work, exploring the future of work, labor, and employment. In our next episode, Dean Colvin talks with New York State Assemblyman Sean Ryan about Buffalo's economic revitalization and its impact on work. Again, thank you for listening, and learn more about ILR by visiting us on the web at ilr.cornell.edu.